If I may, I actually would like to focus on arguments 3 and 4. If the court has any questions about 1 and 2, that's fine, but I think 3 and 4 are more important.
I do have a question about the public trial, which is, what about the judge's findings? He credits the victim witness advocate, he credits the court officer, that people are in and out, that the victim's family is there, the defendant's family is there, and he doesn't credit Anthony Morris. What do we do with that?
I don't know, but she didn't. I agree with you. I mean, I read the judge's. It's Judge Roop, and she did credit the findings of the court officer over. But there were 3 or 4 witnesses from CPCS that really had no reason to fabricate or to not tell the truth either. The attorney who testified and the investigator that testified said they were excluded and couldn't get into the courtroom. So yes, she did credit the court officer. I mean, I don't know what you do with that.
Okay. And are you going to talk about the voluntary manslaughter or not? No, because what about the Castle defense?
Excuse me?
It wasn't brief, but the Castle defense, even if your facts are true. I mean, he had broken earlier, and she has a right to defend the house, doesn't she? I know it wasn't brief, but I'm just curious what your thought is on that.
This case is a weird case. I mean, the facts are strange. He dated the girl. They seemed to love each other, and the family seemed to love him. They invited him into their home, and all of a sudden one day he came and did that weird thing a week before, and yeah, she saw him come in again, and I guess the facts could easily be that she was trying to defend herself, and it was self-defense. But no instruction was given about involuntary manslaughter, and it was asked. I mean, it could have been supported by the facts, and that is an issue.
Was his mental status at issue?
Excuse me?
Was his mental status at issue?
It never was. There was never a diminished capacity defense presented.
No, huh?
This came out of nowhere. It was, and I got to say, I just tried a case that was like this, where there was a breakup, and all of a sudden there were 32 stab wounds, and in the case I just tried, the girl was killed, but there was no violent incidents up to that, and this is like that. I don't, it's one of those. It's hard to explain, which is why I think 33E review is strong in this case, not only because of the impulsivity and the fact that it came out of nowhere, but because of the age of the defendant and the testimony of the psychologist that talked about adolescent brain development.
Leading to that 33E review, Mr. Black, there are very few homicides that we see that make sense, right? I mean, they're all extraordinary, and you say, why the heck? But here we have a breakup that's taken hardly, and obviously you did a nice job laying out the relationships in the brief. But here there is an explanation in that he can't take no for an answer, and we have lots of domestic violence cases where there's a bad breakup, and then usually the husband or the boyfriend or something goes wild and commits a murder. Isn't that the case in all these? How is this different? Well, put the age aside. How is this different from all those?
All of the cases that I've tried involving this are weird, but this is not just a domestic breakup where this is a 19-year-old kid who, by all appearances, had a good relationship with the family. I mean, they liked him.
Right, and they didn't call the police on him after the first incident.
Yeah. And then he had that weird incident where he came in and he put his hand over the girls, and the girl was freaked out, and then a week later came in again and killed her mother out of nowhere. So Yeah, all domestic breakups are strange and have their own fact pattern, but this one seems to be very impulsive and out of nowhere. You know, didn't bring a murder weapon to the scene. It didn't appear that he came to the scene to intentionally do anything. Didn't appear that way. And then all of a sudden, you know, mom came in, and maybe mom was, I mean, we don't know exactly, but maybe mom was freaked out because of what happened the week before. And then all of a sudden, the girlfriend looked and saw this guy stabbing her stepdad, and her mom. It's just so impulsive and out of nowhere that it is a little bit strange. But you're right about domestic breakups in general being all strange. I mean, like I said, the one I tried was 32 stab wounds. That was just, again, out of nowhere. And it's hard to explain when it comes from such a young kid who had such a bad childhood, which I think I briefed in the 33E review.
Yeah, and I'm trying to struggle with the extraordinary part of extraordinary remedy, right? And what makes this extraordinary?
But you asked me what makes it extraordinary other than the age. And it's not just his age, although I think the age is...
No, I mean, we look at it in total. I get it, and it's not fair probably for me to say take aside the age. And that's your argument is part of it.
Is a strong part of it. But he also... he also had a horrible childhood. So when you add the age and to it, I think you have something that is extraordinary.
Was that part of the evidence? So I mean, no doubt on your sentencing argument, and if as amicus briefs Cepalonis, that's all important. But was all that evidence in about his siblings, and was that part of the evidence?
It was part of. Attorney Rudolph did an extraordinary job. I know sometimes on 33E reviews you don't have enough to actually look at the record in total, but yes, all the things about the siblings came out at sentencing, in his sentencing argument.
But does it have to be part of the trial?
I don't think it has to be part of the trial, as long as it's part of the sentencing on the record.
Well, I understand we can consider it on sentencing.
Yes.
I get that.
Bless you.
I understand that. And I apologize. I should know the answer to this question. But I know we can consider it on sentencing and the amicus argument on Cepalonis. But on 33E, aren't we confined to the trial record?
Well, I don't understand why the sentencing wouldn't be part of the trial record. I mean, sentencing is part of the trial record. And Attorney Rudolph made sure that it was part of the trial record in terms of the sentencing hearing. I mean, a lot of times what happens to trial lawyers is they go into a sentencing and they'll just say, listen, you have to impose life without parole because it's a first-degree murder, and don't say anything. I think that's been changed lately, and I think a lot of I know I do. I make an effort of putting that in the sentencing.
The thing with I think his sister, and he's pulling the person off
The sister.
All that's in there?
Well, all that was argued by Attorney. So Attorney Rudolph actually made a motion for the judge to go under the mandatory life sentence, and she just said, I can't, and she couldn't. I mean, that's correct. But I think Attorney Rudolph made a very good effort of preserving this and putting this all on the record.
Was there evidence of it?
Excuse me?
Was there evidence of it?
Other than a sentencing argument, no.
Because the amicus suggested in a proper case where there is a fuller record, this might be an issue that would be a good thing to bring up, but I think the suggestion is this is not a full enough record to do it.
So I'm glad you brought that up, because I think Attorney Schiff is correct that it's not it's not as developed as it could be. Just sort of the court's information, Attorney Schiff is developing it on his case, and has a Rule 30 pending and is going to have a hearing on it. I know Attorney Greenberg is bringing up a case with you soon, and I don't know how developed it is, and I know Attorney Sapaccio is doing the same thing. So there are going to be about 4 or 5 cases coming up that they may be developing a fuller record than this.
In terms of the evidence?
in terms of the evidence. I know Attorney Schiff did a really nice job in terms of developing his case and is continuing to develop it. I think he wants to call Dr. Steinberg at a hearing, on a Rule 30 hearing, to show about, adolescent brain development. But there was testimony in this case from Dr. Bartholow about adolescent brain development not being fully developed until the ages of 22 to 25. I don't know how. I understand the courts have to have some kind of line. Okay, so you're Miller and Shevchenko said under 18. But there's no reason that it should be that age. I mean, there's no reason established that it should be that age. The scientific studies now are showing that it could be somewhere between 22 and 25. And that's what Dr. Bartholow testified to. And he was allowed to testify to. It may not be as fully developed as Attorney Schiff wanted it in terms of having a full Rule 30 hearing. But I decided personally not to do that in this case because I thought there was testimony presented, both at sentencing and at trial, because Dr. Bartholow was allowed to testify fully at trial and was cross-examined. Mm-hmm. But now there are more studies, and I think that's what Attorney Schiff wants to say. That's why he said that the record wasn't fully developed, because I think now there are more studies showing that age. Now his client was 18, and he's asking for the age to be pushed to 18, and to consider 18-year-olds. My client's 19. So I think it's so arbitrary. I mean, what if the client is, just turned 18 2 days before, so that means he doesn't have the protections of Miller? It just seems very arbitrary, especially when the scientific studies are saying that the adolescent brain development isn't until later, 22 to 25.
Okay, thanks.
But it is true that the amicus brief would like the record to have been more developed, and I think he's going to do that in his case coming up.
Yep.
So along those lines, so the amicus brief wants to change factor 2 and 3 in Cephalonus and talk about issues such as personal and family history. You'd say that's already to some extent part of the record. The nature of the offense is part of the record, obviously. Whether or not there's post-rehabilitation is part of the record. So I guess what you'd say is the mitigating impact of youth is what would need to be more developed for the modified Cephalonus.
The mitigating factor of youth, and in this particular case, his childhood, and how he was brought up, because I think his social upbringing was so hard. And then you have the fact that he was so young, and then you have the fact that he, immaturity and frontal lobe development, and all of that together. I think you have an extraordinary, I think we have an extraordinary circumstance that warrants a 33E reduction in this particular case. How you do it, I'm not sure. I mean, you can just say in this particular case, with this particular client, with this particular background, he should have a life sentence with the possibility of parole. Or you could extend Miller and Shevchenko to include an older age group. I mean, I know under Upton, the Constitution of Massachusetts, the Articles of Declaration are larger than the federal Constitution, than the U.S. Constitution, and you certainly can do that. Whether you wait or not to see how the studies are presented in Attorney Schiff's case and in Attorney Goldberg's case and in Attorney Sapaccio's case, I think is up to the court. But I don't think there's any reason to have this age, this arbitrary age at 18. Because I don't think it matters if you're a day older at 18 or if you're like a day older at 19. I think it's pretty clear that the scientific research says your brain isn't developed until around 22 to 25. But then what do? Do you say it should be at 25 or it should be at 24? I don't know how to answer that question either. But I think the scientific studies show that it's really, when you're a teenager, whether it's 18 or 19, your mind isn't fully myelinated. Your brain isn't fully myelinated. I mean, I could talk from my own experience. I know mine wasn't, but I think it's pretty clear that adolescent brains are still developing. So if you add that argument 3 to 33E review and to this particular kid's background, which was raised in the sentencing hearing, I think you have an extraordinary circumstance for 33E review. So you got the age, you got the impulsivity, you got the fact that he probably did not bring the weapon to the scene. You got the fact.
Why do we think he didn't bring the weapon? I'm not sure.
Because I think the weapon that was used was a weapon that was at the house.
Is that clear from the record?
I think it's somewhat clear.
He brought a knife the first time, right?
He did. Well, I don't know that that's clear either. He had a knife when he was over his girlfriend, but whether he had it there or whether he brought it, I'm not sure.
I don't understand. He's in her bedroom, right? And he has the knife up against her. It's not like he's running back and forth to the kitchen, right?
We're talking about the first incident.
Yeah.
Yeah, I agree with you.
And the second incident, what basis is there to assume that he didn't bring the weapon?
Because the mother, now whether the mother grabbed it from him or not, but the DNA evidence was very clear that the mother's handler's DNA was all over the knife.
Well, that would.
It's her kitchen, right?
Well, yeah, no, it's her kitchen. Absolutely. So did he use a kitchen knife and did not bring it to the scene? That seems to be implied by, I think it was Lynn Schoenweiss's testimony about the DNA. And I think it was over several parts of the knife, not just one part. So it appears that she at least handled the knife at some point. So that's why I say I think he didn't bring it, but it's not 100% clear.
The testimony regarding him being 19 and his brain came during the course of trial, focused on whether or not that there was, I assume, whether or not he was premeditated or whether or not he had the intent to kill. Was there any discussion at the sentencing hearing as to whether or not that testimony should be considered by Judge Roop in deciding what she should do?
I don't think so.
So we don't have any testimony or any reference to testimony at the sentencing hearing that there's something inappropriate about sentencing somebody below. We just have the general argument that he's 19 and he asked the judge to go beyond where we have gone in Diachenko.
The testimony, so Dr. Bartholow actually testified at trial.
Right.
He used his testimony at trial as part of his sentencing argument, clearly. So there was testimony about his, about frontal lobe development, et cetera, at trial. But he didn't testify at a sentencing hearing. And whether we should have done, in this case, I think about it, whether I should have done a Rule 30 and tried to call witnesses in this case, I decided not to do it because of the fact that he did testify at trial, and I thought the issue was fairly developed, even though I know Attorney Schiff is saying that there's more that could be presented. I agree. There are more studies now and more doctors now that would testify that your age, that at 19 your brain development, it's just not. So the extension is that the constitutional legality of Miller should be applied to an older age. I don't know how you decide what age, because even if you say 23 or 24 or 25, there's going to be somebody who's 25 in a day who says that it should apply to him.
We know anything about post-defense rehabilitation, because that's also a factor in the amicus brief post-Cephalonus modification of the prongs 2 and 3.
Well, Bartholow did testify that, and I think it's clear in Miller that at that age, you can't really just say, well, he's beyond rehabilitation and he's beyond hope, because at that young age, it's not beyond hope, and I think that's what the studies say. Now, whether that was presented well enough in this case, I don't know that it was, but I think Attorney Schiff is saying that there are clear studies that will be presented to you at some point that say, when you're 17 and 18 and commit a crime, you're not beyond rehabilitation. And this kid, as when when I met him, I mean, he was the most gentle, sweet, nice kid, you know, you've ever seen, and polite to me, and all of that. So what does that mean? He just had a moment. It's hard to explain that.
All right, thank you. I'm afraid your time is up.
Thank you.
Ms. McMahon.
May it please the Court, Catherine McMahon, Assistant District Attorney for the Hampden District for the Commonwealth. Briefly on the public trial, one, the defendant didn't contemporaneously object, so it's procedurally waived, so it's a substantial likelihood test. But more importantly, the trial judge, after an evidentiary hearing on the motion for new trial, found that the courtroom was open. There were members of the public present, and she did not find that any court officer had excluded anyone. Yes, it was filled to capacity, but as people left, other people came in. There were members of the victim's family, members of the defendant's family, the defense bar, the prosecution, and other spectators. The courtroom was open. The space is physically finite, but the public was present. As to the defendant's request for a voluntary manslaughter instruction, he asked for voluntary, not involuntary. The trial judge denied the request, and he objected again at the close of the jury instructions, so it's preserved and the court looks at it for prejudicial error. I submit that the defendant's grounds for voluntary manslaughter are speculative. The victim and both victims were potentially contributors to the DNA that was on the handle of the knife. The handle of the knife had blood. The blade of the knife had blood. There's nothing that puts the knife in either victim's hand. There's nothing.
Does the DNA put the knife in the defendant's hand?
Yes, Mr. Harmon and the defendant's girlfriend both said that they saw the defendant stabbing Mr. Harmon, stabbing the decedent, and
Mr. Harmon lived?
Yes.
Wow.
And testified.
Lived and testified.
And was he the first person to confront the defendant?
He was the first person that the defendant confronted. There was a noise and the dog barked, so the decedent asked Mr. Harmon to go out and check if there was something going on. He went out towards the kitchen to the back door. He smelled an odor from the basement, so he knew the basement door was open. The defendant had come in through, there's circumstantial evidence that the defendant had come in through a basement window, which led into the kitchen. At the first incident, the defendant's girlfriend said that the knife that he used in the first incident the week before was from her kitchen. So he could have armed himself with a knife from the kitchen, and then the mother comes into the kitchen and says he's in the girl's bedroom. The defendant comes out of the girl's bedroom and attacks Mr. Harmon. He kicks him, he then stabs him with the knife, and once Mr. Harmon is down, he turns on the decedent.
So the first person to see him, the first person, I guess, to see him in the apartment was the former girlfriend.
On the night of the murder, the first person who saw him in the house was the decedent, because she either saw or heard him, because she comes out to the kitchen and says to Mr. Harmon, he's in the girl's bedroom.
But she was asleep at the time?
The girl.
So she didn't see him.
The 15-year-old girl was asleep. She didn't wake up until she heard Mr. Harmon screaming.
Okay, so the first person to actually see him in the apartment was Mr. Harmon.
Yes.
And when Mr. Harmon saw him, am I correct that that defendant was armed with a knife at that time?
He was armed with a knife. He was wearing a mask. He judo kicked Mr. Harmon, and then I think he slashed his throat. I think he tried to stab him in the eye. Mr. Harmon fell down. Then he was screaming. The girlfriend woke up and came to the kitchen. She saw the defendant stabbing her mother, with her mother having her arms raised in a defensive posture.
And was there any evidence that Mr. Harmon had grabbed a knife when he believed somebody had entered into the house and was sort of confronting him with a knife himself?
No.
And the evidence, did they establish whether the knife comes from the kitchen or not, or it's sort of left unclear?
That night, it's a kitchen serrated knife. I don't say.
We don't know whether it's from the defendant's kitchen or their kitchen? We assume it's from their kitchen, I
We
take it?
assume it's from their kitchen.
And the idea
And he
is,
wasn't charged with home invasion.
the idea is that he got the knife the first time from their kitchen so that when he comes the second time, he knows he can get the knife from their kitchen? Is
And
that-
he came in through the cellar, which leads to the kitchen, and then the bedrooms are beyond that. So he had an opportunity to arm himself in the kitchen.
If there were an excessive force self-defense issue as it relates to manslaughter, what would be the impact of the castle defense on that?
Was the occupants wouldn't have to retreat to the wall before resorting to self-defense, but there's no evidence of an encounter between the mother and the defendant in the bedroom. There's just a speculation based on the fact that her DNA is on the handle of the knife, and she also had told her daughter after the first incident that the defendant would have to come through her before getting to the daughter. So the fact that she expressed a willingness to protect her daughter, but she either hears or sees the defendant in the girl's bedroom and runs to Mr. Harmon.
So can you address the 33E issue and the Diachenko issue?
In terms of 33E, apart from the age, the defendant, the girlfriend broke up with him after the first incident a week before, but they were still in communication, and he was trying to get back to her, with her. And I think in either a text or a phone conversation that night before she went to bed, it's like he realized that it's completely over, and he says that he's not going to bother her anymore. But then he takes a bike and rides 7.5 miles to their house. He breaks in through a basement window. He puts a mask on. He arms himself with a knife. He goes into her bedroom. The adults are up. They discover his presence. He attacks the man. The man goes down. He attacks the mother. The man tries to intervene by picking up a kitchen stool and pushing it against the defendant. The defendant turns on him again. The girlfriend daughter, she comes out. She tries to run away. He pulls her back. As Mr. Harmon's trying to get out the back door, the defendant is stabbing him. I think he had 3 stab wounds in his back. His lung was punctured. His diaphragm was torn. Both the daughter and Mr. Harmon managed to get outside. That's how the attack ended. But once he brought the girl back into the kitchen, he slashed her mother's throat, kicked her and slapped her and said, "Now you're out of the way." This was deliberate premeditation. This was extremely atrocious or cruel. Based on the fact it's a sustained attack without provocation, without any need for self-defense, and he goes back to each stabbing victim. It's more than one assault. So based on that, there's no basis for reducing the verdict or overturning. There's no trial error warranting a new grant of a new trial. In terms of the age of the defendant, he was 19. There was evidence before the jury that he had not done well in school. He had stayed back at least in 3 grades, I think maybe 4 times. He lived with his family. The other children in the house were younger. His girlfriend was younger. She was 15 and he was 19. He spent a lot of time playing video games, including violent video games. So the defense expert testified that the juvenile brain isn't fully developed, that they're more impulsive, and he also testified to the effects of playing video games and violent video games on people's aggressivity or aggression. But there was nothing before the jury about this defendant's mental state. He hadn't examined him. It was just like characteristics of juveniles for the jury to apply. The defendant did file a sentencing memo claiming that a sentence for a 19-year-old was unconstitutional under both the state and federal constitutions as cruel or unusual punishment. The trial judge declined based on that she was bound by law, and also she described this as a vicious attack that warranted life without the possibility of parole.
As to that, if we go back to the record, is it clear that she said that even if I had the discretion, I would not exercise it?
She didn't say if I had the discretion. She says that for two reasons. One, that's what's statutorily mandated, and two, based on the facts.
Wasn't there, along those lines, didn't she impose a from and after sentence? Judge Roop, maybe on the assault with intent to rape from the week before. I think there was a from and after sentence which might speak to this issue.
Yes.
Okay. It's 7 to 8 or 6?
Yes, 7 to 8.
Okay. What do you think of that as it relates to the chief's question? The fact that she imposed a from and after sentence. Does that speak to whether anything about if she were to exercise discretion? Can you read anything into that from and after?
I think reading into it that there was more than one victim, and she imposed sentences that applied to more than one victim. And the from and after, I think, speaks to the whole vicious scenario where 3 people were attacked in the home, one severely injured, one killed, and the girl managed to escape.
Yeah. I guess what I'm thinking is it's unlikely that she would have chosen, if she thought Tianchenko should apply to 18-year-olds, or the amicus sepalonis sort of doctrine, that she would have imposed a sentence less than life or life with the possibility of parole when she knows that's the sentence and chooses to impose a sentence more than life without parole.
I think that she thought that this warranted the most severe penalty, including the from and after. There was a pitch by the defense to apply Diachenko to a 19-year-old. She knew she was bound by the state of the law. I don't think there's enough for the judge on this record to have made a really informed decision about the social science. She didn't hear of several studies. I think that's something that either has to be explored by the legislature or needs like a greater record for this court to address. Both, not just one expert talking about, you're more impulsive at 19 than you are at 25, but like more in depth. He focused a lot on the video game studies.
Yeah, what are we to do with that, since they're everywhere? I mean, if we're going to say that violent video games are going to be viewed as mitigating, then we're going to be including most of the population under 50, maybe even those over 50.
I don't know what you do, because in his study, people who played violent video games, they were like tested like shortly after, and they were more aggressive in like hitting like a sound device when they were playing against somebody to like scare or jar the person they were playing against. But there was no testimony about how somebody who plays violent video games is more aggressive or more violent as a character in their life. It was what they did in the laboratory in this setting. So again, I think they're probably, I know there's social science out there, but this record doesn't delve into it enough. This court has said, I think, in Okoro, that this is a rapidly developing social science, and there's lots of studies, but that was 2015. It's now 2019. I think you need a bigger record, a broader record, with both sides exploring the issue of the social science before making a determination. And after receiving the amicus brief, it was filed after my brief, I did some research, and I apologize, but the state of Vermont statutorily has elevated its juvenile cutoff, and it's staggered like from 2020 to 2022. It's 18 from 2022 to, like another year, it goes up to 20, but it excludes several offenses. They're enumerated in the statute, and murder is one of the offenses that's excluded from it. I know, like, the U.S. Supreme Court in Graham had said that one place to look to see where society is what the legislatures have done. I found Vermont has done it, but has excluded it for murder. I think the majority of states have it at 18. That's
And
not,
that's the third Cephalonus factor, too. Just look at other states.
and that's just like one factor.
Right.
But that shows you, like, the consensus. I know that there's a dispute in the federal circuits as to whether Miller applies to people who are 18 or above. I think the Illinois case that's cited by the amicus has been vacated by the Illinois Supreme Court. So that case applying it to 18 it's been vacated.
Okay, thank you.
Thank you.
Hear ye, hear ye, hear ye. All present have anything further to do before the Honorable Justices of the Supreme Judicial Court, now sitting at Boston, within and for the Commonwealth. At present, the fact that sitting at this court is now adjourned.